Salam Sejahtera Doctor, we are from Group 10. Today we are going to present our business law group assignment. This is our member, Li Ping, Teo Seng Yu, Chi Wan Yun, Chao Yashan, and Omini.
For the introduction, this report discusses a business dispute between Ketapang Trading Company and Jemba Sdn Berhad. The dispute centered on complex supply agreement involves proprietary semiconductor component intended to support Malaysia electric vehicle industry. Ledger issues in the case arise both before and after the contract was formally established, highlighting various concerns under Malaysia contract law. The relevant Malaysia law applies such as Contract Act 1950 and Sales of Goods Act 1957. We use ILAC method to provide a clear and logic solution to the ledger problem in the case, which the I stand for issues, L stand for law, A stand for application, and the last one is C, which stand for conclusions. First, I will present the issues offer and acceptance. For this issue is whether a valid contract was formed between Ketapang Trading Company and Jemba Sdn Berhad from the request for proposal and the memorandum of understanding. According to Section 2 of the Contract Act 1950, a valid contract begins with a proposal or offer as stated in Section 2A. When the offer is accepted, it becomes a promise under Section 2B. Next, a valid contract must be considered under Section 2D and finally become an agreement under Section 2E when the promises are submitted by consideration. Next, under the Section 7A of the Contracts Act 1950, to convert a proposal into a promise, the acceptance must be absolute and unqualified. In the case of Gibson v. Manchester City Council 1979 was the same case with the Ketapang and Jemba. Mr. Gibson is a tenant who received a letter from Manchester City Council about they may be prepared to sell the house to him. After that, the Manchester City Council suddenly refused to sell the house to Gibson. The court considers the offer to be invalid because the letter did not constitute a valid offer but viewed as an invitation to trade. Next, for the applications, the request for proposal issued by Ketapang Trading Company was only an invitation to make an offer, not to create a contract immediately if they responded. This is because RFP included uncertain terms such as delivery timeline. The delivery timeline in this case are based on monsoon condition and port availability. Next, Jemba Sdn Berhad responded with a memorandum of understanding that did not accept the all RFP terms but provided the new terms such as increase the 10% price and sliding delivery scheduler. From the perspective of Ketapang Trading Company, Jemba Sdn Berhad failed to comply with Section 7A of the Contract Act 1950. This is because Ketapang mistakenly assumed that the proposal had already been accepted by Jemba. Next, from the perspective of Jemba, there was no violation of Section 7A of the Contract Act 1950. This is because Jemba assumed the RFP was an invitation to trade, and they responded the MOU was not to accept a binding offer, but rather to preliminary negotiations. In conclusion, the position of Jemba Sdn Berhad correct and no valid contract was formed between Ketapang Trading Company and Jemba Sdn Berhad under Section 2 because it did not have acceptance.
Now I want to talk about the authority of agent. The key issue here is whether Ketapang Trading Company is legally binding with the contract signed by its agent who act exceeding his actual authority. We can refer to three important sections under Contract Act 1950. Firstly, Section 164. If there are not clear instructions, an agent must act in the usual way the business done. Secondly, the Section 149. If the agent acts without permission, the principal can choose to either ratify or reject that unauthorized act. Next, the Section 190. If the principal word or action cause the third party to believe that the agent has authority, then the principal cannot later deign it. In the case bottom partner with Lambert, the principal ratified the agent act after the contract was signed. The court held that the ratification back to the time when the agent was first accepted the contract. Now apply to our case. Regional Operation Director as agent, Ketapang Trading Company is principal, and the Jemba Sdn Berhad is third party. Now the agent on behalf is principal and sign a contract which exceeding 30 million. This shows that the agent is acting outside his actual authority and brought the company instructions which refer to a breach of duty under Section 164. In conclusion, Ketapang Trading Company as a principal can choose to ratify or reject the agent unauthorized act. If the principal chooses to ratify it, it can be considered a valid contract which legally binding on Ketapang Trading Company and the Jemba Sdn Berhad. And the agent treated as he has the authority of the principal at that time, therefore he can exempt from liability. Agent signed the contract formally in public on behalf of the ketapang, and the principal did not stop the behavior in time, so that the jemba can mistakenly believe that the agent in fact has authority, then sign with him. The ketapang could not be expelled from dealing the regional operation director authority.
Next, I will present uncertainty. The issue is whether the flexible delivery clause leads to uncertainty that renders the contract unenforceable. For the contract to be enforceable, the terms of the offer must be definite, clear, and certain. So this issue is related to the Section 13 of the Contract Act 1915. This section is stated that agreements are deemed void if the meaning of it is uncertain or capable of being made certain. A contract which is uncertain cannot be enforced, especially did not clearly state essential terms such as price, quantity, and delivery time. In Karupa Chetty versus Swan Tien 1916, the lease agreement concerning the land expressed rental payment of 35 ringgit per month and the lease period in the terms of for as long as he likes. This phrase failed to specify a clear and ascertainable period. Therefore, the court concluded that this agreement is void due to uncertainty of the essential terms. Furthermore, in the case of TK Tankers Limited versus STX 2017, the delivery date of the vessel would be mutually agreed upon when option were exercised without any specific standard or alternative mechanism. The date of delivery cannot be determined, thus is considered non-binding agreement to agree. Therefore, the High Court held that an option agreement to purchase an oil tanker was void for uncertainty. In this case, the contract includes the flexible delivery clause stating shipment to be made as production capacity permits, subject to local public holidays and seasonal consideration. This contract did not mention and cannot be expected production capacity of Jemba Sdn Bhd. It gives broad discretion to Jemba to determine the delivery time. Jemba may potentially delay or not deliver within a specific or reasonable time frame. Seasonal considerations are subjective and cannot be predicted in advance regarding when shipment will be made. Thus, it is unclear and indefinite to determine the time of delivery and subject to Section 13 of Contract Act 1915. In conclusion, the failure to specify a precise date of shipment make the contract void due to uncertainty of the terms of the contract under Section 13 of the Contract Act 1915. Next is exclusion clause. The issue is whether an exclusion clause attempting to waive some statutory warranties and consumer protections is valid and enforceable. Under Section 16, subsection 1, paragraph A of Sales of Goods Act 1957, if the buyer expressly or impliedly tell the seller about particular purpose required for the goods, which show the buyer relies on the seller's skill or judgment, and goods are of a description is in the course of the seller business to supply, there is an implied condition that the goods shall be reasonably fit for such purpose. In addition, Section 16(1)b state that implied conditions of the goods shall be of merchantable quality if goods are bought by description from a seller unless the buyer make inspections of the goods and discover defects. According to Section 29 Contract Act 1915, any agreement by which any party is absolutely restricted from exercising its rights under contract or is restricted in the time at which it may exercise its rights shall be void to that extent. In the case of Premier Hotel Sdn Bhd versus Tan Ling Seng 1995, a hotel receptionist accidentally handed over one guest key to another guest. Consequently, the guest lost belongings in the room. The hotel involved an exception clause, that is, the hotel will not assume responsibility for valuables or money lost from the room. The court held that the clause was not expressed and therefore did not relieve the hotel from liability for negligence. In this case, Jemba Sdn Bhd contains an exception clause to avoid its attempts to waive some statutory warranties and consumer protections, including those required under the Malaysia Consumer Protection Act 1999 and the Sales of Goods Act 1957. The exclusion clause should be clear, specific, and unambiguous in the language of the contracts. If the product supply is unqualified, which brings loss to Ketapang Trading Company, the exclusion clause may restrict Ketapang's implementation to the right. Thus, it is void under Section 29 Contract Act 1915. In conclusion, the exclusion clause is not enforceable under Section 29 Contract Act 1915. It cannot exclude statutory obligations of Jemba Sdn Bhd, since it is not clear and waive the statutory warranties and consumer protections which require under the both laws.
Okay, next, I want to talk about coercions. The issue of this case are whether the contract is signed between Ketapang Trading Company and Jembal Sdn Bhd, and does this affect the legality of the contracts, and does it constitute signing the contract under involuntary situation or free consent. And this case is under Contract Act 1950. The first one is Section 10. Section 10 is stated about a valid contract must be made with a free consent of parties. And consent is not free when it is influenced by coercions, undue influence, fraud, misrepresentations, or mistake. And the next one is Section 15 is talk about coercions. Coercions is doing or threatening to do any act forbidden by the penal code, or unlawfully detain or threatening to detain property, to harm someone with the intentions of causing them to enter into an agreement. Okay, the next one is Section 19(1). It's talk about effect on coerced consent. The agreement is void at the option of the party who gave the consent when a consent to an agreement is caused by coercions, fraud, or misrepresentations. And the last one is Section 92. It's talk about option to continue. The innovative parties who has given consent due to fraud or misrepresentation may insist or can continue with the contract as though the fraud or misrepresentation did not happen. And the last, the case law. I chose the case law in Barton and Armstrong in 1976. A contract was held voidable as Barton signed it under death threats, even though he had other business motive. Okay, next, the application of this case is 2 days before the contract, CEO Ketapang, which is Datuk Seri Sadat, received an anonymous email threatening to expose private photo if he didn't sign the contract. The threat likely caused CEO reputational damage and psychological pressures. However, the contract was not signed by the CEO, but signed by the regional operation director of Ketapang, who was not authorized to sign contract value over 30 million ringgit Malaysia. And the CEO only report the threat 6 months later. However, they will consider several questions such as, was the threat is direct cause of the contract? Were there other reasons why the CEO did not directly disclose the threat at the time? And did the CEO immediately protest or cancel the contracts? Okay, in the conclusions, under Section 19(1) in Contract Act 1950, this agreement is contracts voidable at the option of the party which is Ketapang Trading Company, which means Ketapang can whether it want to maintain or direct void the performs the contracts.
Next, I'm going to present the issue related to fraudulent misrepresentation and SOGA 1957. The issue is, did Jemba Sdn Bhd make a misrepresentation by claiming that the semiconductor components had met the specific requirements of Ketapang Trading Company during the contract negotiation? The law is, according to Section 10, Subsection 1 of the Contract Act 1950, an agreement becomes a contract if it is met with free consent. Under Section 14, consent is considered free when it is not caused by caution, under influence, fraud, misrepresentation, or mistake. Under the Contract Act 1950, Section 70 defines fraud as when a party of the contract deceives another party intentionally to enter into the contract. In contrast, under Section 18, misrepresentation includes any breach of duty which gives an advantage to the person committing it without an intent to deceive. In the Dairy versus Pig 1898 case, Locke herself said that fraud is proof when it is shown that false representation has been made knowingly, without belief in its truth, and recklessly whether it's true or false. For the law related to SOGA, Section 16, Subsection 1, Paragraph A of the Sale of Goods Act 1957 says that when a buyer makes known to the seller the particular purpose for the goods are required, this means the buyer relies on seller's skill or judgment. There will be an implied condition that the goods shall be reasonably fit for that purpose. For instance, in the case Priest versus Last 1903, the claimant purchased a hot water bottle from the defendant. When the claimant's wife used the hot water bottle, it burst and injured her. In this case, the court held that the hot water bottle was not fit for its obvious and common purpose. For the part of application, applying the principle in Dairy versus Pig 1889, as Jemba knew the statement was false and recklessly disregarding its truth, intending to induce Ketapang to enter into the contract. Therefore, the situation appropriately falls under Section 17 of Contract Act 1950, fraudulent misrepresentation. In addition, since Ketabang clearly requests the specific temperature required in the contract and relies on Jemba's profession, Sales of Good Acts 1957, Section 16, Subsection 1, Paragraph A being applied. In this scenario, similar to the case law Priest versus Last 19 and 3, the components from Jemba were not fit for the specific purpose required by Ketabang and breached the implied condition. In conclusion, according to the Contract Act 1950, Section 19, when consent to an agreement is caused by fraud, the contract is voidable at the option of Ketabang Trading Company. Furthermore, Ketabang entitles to reject the goods and claim damage under Section 12, Subsection 1 and 2 of the Sales of Goods Act 1957 respectively.
Next, discharge of contract. The key issue here is whether Jemba Sendiang Berhad failure to deliver will constitute a breach of contract or can be executed as flotations. We can refer to important sections in Contract Act 1950. Firstly, Section 40. When a party to a contract has made it impossible for themselves to fully carry out their promise, the promisee has the right to cancel the contract. Secondly, Section 65. The party who rescinds the contract should restore the benefit obtained from the contract. In the case given Chi and Ano, with Pacific Forest Industries Sendiang Berhad, the Federal Court held that the frustration of the contract required a fundamental change, and the event must make it impossible to carry out the contract or materially different from the performance initially agreed. Now apply to our case. Jemba Sendiang Berhad could not fulfill its delivery obligations due to factory fire caused by lighting, so that its production facilities were destroyed. It referred to a fundamental breach of contract rather than flotations. This is because the contract was still able to perform, and Jemba Sendiang Berhad, being a manufacturer, is expected to have contingency production plans or insurance in place to manage risks. In addition, the failure of delivery by Jemba Sendiang Berhad had caused heavy loss on Ketabang's side. In conclusion, the contract is voidable. Ketabang Trading Company can whether to continue or stop the contract, and it also can claim remedies for damage suffered due to non-perform under Sections 74 to 76 of the Contract Act 1950. Lastly, both parties required to restore what they received based on the equitable principle of restitution. Lastly, for remedies, the issue is what legal remedies that Ketabang Trading Company may claim under Malaysian contract law. We can refer to the Section 74 in Contract Act 1950. The innocent party can claim compensation for natural and foreseeable damage, but not claim for losses that are too speculative or indirect. Secondly, the Section 76. The innocent party can claim damage for any losses resulting from its non-performance after rightfully rescinding the contract. In the case Tam Choto with Associated Mental Smelter in 1972, the defendant sold equipment that couldn't reach the required temperature, making it unusable. The court held that loss of profit from the delay and failure was foreseeable, so that plaintiff could claim special damage. Applied to our case, since Jemba's failure to deliver specialized microprocessors amount to a fundamental breach under Section 40 of the Contract Act 1950, this breach prevented Ketabang Trading Company from fulfilling its contractual obligations to margin clients, which is Proton Imas divisions. The effect for Ketabang Trading Company are Rm 7.9 million in liquidated damage and termination of Rm 25 million annual contract. In conclusion, Ketabang Trading Company rightfully rescinded the contract, and it can claim compensation under Section 76 for non-performance, including Rm 7.9 million in liquidated damage. Since Jemba knew the importance of the order, Ketabang may also claim special damage under Section 74, such as the termination of the 25 million contract and the reputational loss.
In conclusion, there was no valid and enforceable contract between Ketabang Trading Company and Jemba Sendiang Berhad. The agreement failed due to lack of clear acceptance, uncertainty in essential terms, and unauthorized actions by the agent. Even if the contract were considered valid, it would be voidable due to fraudulent misrepresentation and unenforceable exclusion clauses. Therefore, Ketabang Trading Company is not legally bound by the contract and has the right to reject it under Malaysian contract law. That's all from our presentation. Thank you.